Training sessions in the past, and there's been some kind of crossover between commissions, but I don't think we've ever had all of the commissions all together in one place. So this is pretty cool. Before we do the introductions, I wanted to kind of lay down a couple of ground rules. We do want this training session to end about 7:45. Because as most of you, some of you may know, immediately following at 8 o'clock, there's a continuation of a public hearing with the UVDC. So between the end of this and the beginning of that at 8, we're going to have to do some chair rearranging. So we'll shoot for 7:45. Any questions that you have during the training session, I want to remind you need to be general in nature. No specific questions about particular projects. They need to basically be hypothetical. I don't think we'll have time for public questions. I don't know if there's any members of the public here, but given the limited amount of time we have and the presentations, and we want to make sure the commission questions are all answered. So I don't think we'll have time for public questions. And I think with regard to introducing ourselves, I think, like I said, since this hasn't happened before, I think it'd be great if we went around the room, introduce yourself, say what commission you're on, maybe how long you've been on the commission. Just out of curiosity, we don't need exact numbers, exact number of years, but whether you're brand new, whether you've been on it a long time, just to get an idea for how long you've been on the commission. And then I would say, if you have real burning questions or something you want to absolutely make sure gets addressed tonight, maybe you could bring that up as well. So with that, I guess we could start the introductions. Well, thank you, everyone. And then interspersed amongst you is some staff members, too, who are apparently too shy to introduce themselves.
Who will not be identified tonight.
Yeah, so. Or they're in hiding, one of the two. With that, I would like to introduce our esteemed speaker for this evening, Mr. Ted Hunter, who he's contracted with the city as our hearing examiner for as long as I can remember, since I was a young planning pup many years ago. And so as our hearing examiner, he hears, for example, appeals, variances, and plats as well. But more importantly tonight, he's a legal expert with regard to public hearings, public meetings, and the public process. So that's why we've invited him here tonight to speak to you, and I'm sure we'll all learn a thing or two. Thanks.
Thank you, Christopher. Mm-hmm. And with me tonight is Andrew Rees with my office, Sound Law Center. And Andrew recently joined us. He spent the last 3 years writing for the Court of Appeals and has some kind of insider information of a practical nature of how courts come about their decisions. We as hearing examiners sort of serve as a trial judge. When we look at an application or an appeal, we do what's called the open record hearing, and it's only at that hearing that you can bring in exhibits and testimony, and if there is an appeal, it's based on that record. So the court system then looks at our record and determines whether or not we made a mistake. We've been very fortunate. We haven't been told we made any mistakes yet, but Andrew was writing for the court. They probably looked real hard at some of those and took a coin toss about whether a mistake was made. Here's what we want to cover tonight. I think each of you, when you came into the room, received an agenda. And the front side is the topics that we're going to cover, and on the back are all the disclaimers that we need to give, that we're not here to give specific legal advice, and that what we're saying tonight is to help you in the role that you play on the various boards and commissions. And as you introduced yourselves, I was struck by a couple of things. One is that about a third of you are brand new. I think 7 or 8 people identified themselves as, this is my first year. Well, that's great. I think this will really help you in how you approach your work with the board or commission that you're on. And some of you, about 5, said more than 10 years, which is really good too, because we're going to need your information and expertise at what types of things you encountered as you've been sitting on those boards and commissions. You know, it is a real blessing to be able to participate in the governmental structure and decision making. I feel very fortunate to be selected by your city, and I work in about 25 different cities. Each one's very unique. You're really blessed in Issaquah to have a really professional staff. I was chatting with some of them before this session began, and Many have more than 20 years of experience, and we kind of grew up together in land use law and land use processes. So you're really fortunate to have a well-informed staff that I'm sure in your work on the boards and commissions you'll recognize that as you go forward. I'm also feeling fortunate tonight that we have this session because it was really interesting for us to prepare for it. What we wanted to give you, and you'll see this on the agenda, is what we have in common. As hearing examiner, I'm always looking at land use law and cases, and my first thought was, oh, this will be easy. I'll just tell them about all the cases that come out. But I think you'd probably rock back in your chair and be asleep within probably 15 minutes because those are cases that already happened. And yes, they provide us some guidance about how we want to do our work. But I think better than that is a conceptual framework so that when you come into your board or commission meeting, you have in the back of your mind, these are the concepts I need to be aware of. These are the things I need to be thinking about as I do my work as a board member or commission member. And that's why we put, for the first thing on our agenda, a light touch onto the Open Public Meetings Act. Andrew did a lot of work in this area with the Court of Appeals, and we're not going to give you case, but let me tell you this, they're all based on cases. The courts do provide us guidance, and as we'll see later in the presentation, the Constitution and statutes as well as your own ordinances. And what we want to touch on with Open Public Meetings Act is just that conceptual framework so when you walk into the room, you know what it's about. Each one of you is subject to that. Each one of you falls under that. And so we'll start with that, and then we'll launch into the main part of our presentation tonight, which is on how to discuss land use decisions. So Andrew, you want to do a little bit on public meetings?
All right. Thank you for having me. So on the Open Public Meetings Act, RCW 4230, it was adopted in 1971. It sort of was a nationwide push to have more transparency in government. And I think the most sort of basic concept is that when a group of decision makers are getting together to decide things, just remember it needs to take place in an open public setting. That's the sort of most basic concept. And we have some true or false slides here. Am I not doing this right, Ted?
Here we go. I'll help you.
There we go. Thank you.
Yeah, these are going to happen throughout the presentation, true or false. And you're not going to be penalized or awarded for getting the right answer or the wrong answer. But the first one, individual decision makers may be held personally liable for failing to hold open public meetings.
It may be helpful for the new commission members if you let them know what an RCW is.
Oh, I'm so sorry. I'm so used to lawyers. That's the Revised Code of Washington. My apologies.
The state statutes.
The state statutes.
No, Keith, you disappointed me. I thought you were going to have the answer.
And
to
you
the
have
first
you have the first answer as well?
Now we're going to turn to you. You go, is that true or false? Who thinks that might be true? Yeah, you don't want it to be true. That doesn't sound good. Personally liable. That doesn't sound good at all.
Unfortunately.
What's the answer?
The answer is that, yes, it is true. Individual decision makers are liable for each, we call them OPMA, Open Public Meetings Act, each OPMA violation. It's $100 per violation. And then in the bigger picture, if a group makes a decision outside of an open public meeting, that decision could be null and void. So all that hard work you did to finally arrive at a decision might be for naught if you violated the OPA. So that was the first.
Yeah.
Can I know we're not supposed to do this. Can you go back to the first slide? So, is the parenthetical element of that up to date?
How often to meet?
Yes.
Yeah, that's based on your current
I
ordinance.
took that out of the current ordinance. Maybe I'm wrong.
So, if the development petition goes for a year or two without a meeting, am I going to go to jail?
See, that's why we're not answering specific questions. But I know you're being a bit facetious, but in all seriousness, we looked at it and we thought, wow, how many people are aware of this? And we just wanted to bring it to your attention that's something you might want to look at. Just the fact that it's in your ordinances is not a per se violation, so I think you can take some comfort in that. But your council, when it adopted and created different commissions and boards, had in mind a certain regular meeting schedule. And if that's not happening, I understand you're doing some code revisions right now, you're in the middle of it. That's why we knew it was a risk to put it in there. And you asked the right question. We didn't want to get into the details of it, but thank you for picking up on that. And that's exactly the type of thing we want you all to think about. If you know that this law exists, you want to be thinking about where might we be in compliance and where might we be in violation, and especially if you just get that uneasy feeling that maybe we shouldn't, we're a 5-member board, maybe 3 of us shouldn't decide this, over coffee. Maybe we need to have this in an open discussion. That's when you can consult with your staff, who will contact your attorney if needed. But just be aware of it, is what we're saying, because it's very strongly worded. You can see there up on the screen what Open Public Meetings Act means to people. We did not give up our sovereignty. We're not delegating authority. We want to be involved. So it's always good to think, let's err on the side of being open in our discussions. And the sanction, like Andrew mentioned, is your decision may be null and void. And we were talking about this earlier today about what's happened. You're familiar with the Public Records Act, where you can request from the city basically anything, and some will be redacted or kept private, but most is given away. Well, that act was used extensively, and it used to be that there was an automatic penalty.
Right.
That if you failed to disclose and should have, there was a penalty. And it was an incentive. A lot of people filed, Andrew, I think you saw a lot of them in the court.
Yeah.
They'd come up to the Court of Appeals level. Well, what's the recent decision you're telling me about?
The Washington Supreme Court recently, actually the legislature recently amended the Public Records Act so that there's technically an automatic penalty, but it could be $0. And
so there could be, in fact, no penalty. So it's removed that act, and more people now that are concerned about government are relying upon the Open Public Meetings Act, because they can get costs and attorney's fees, and they can also render the decision null and void. So we're not going to spend a lot of time because we've got other things we want to get into. But as you're now a board and commission member, you're thinking, okay, keep the outline if you want. I need to be thinking about that Open Public Meetings Act to make sure that I don't violate it. Thank you, Andrew. So now we're going to dig into the thing we all have in common, which is we're holding meetings or hearings, and we'll get into the distinction: open record hearings, open record appeal hearings, public meetings, public hearings, on those aspects dealing with land development. Whether it's setting the policies, looking at a river management plan, or doing specific recommendations and applications, we're all involved in doing hearings work. And what we want to give you tonight are these 3 areas. What we have in common is we need to be aware of the constitutional and statutory background. The statutes are the revised Code of Washington. We need to have a general understanding of what takings means, and we hear that all the time. You can't take my property. I can do with my property when I want to. Government goes too far. We've got to cut back in government. That's all revolves around takings. And then finally, we're going to look at how we do our hearings, how we conduct our meetings, has a real direct relationship to whether or not that decision will be upheld. And courts universally will not disturb a decision, and they will uphold the outcome of your recommendation or plan or land use decision if you follow proper procedures. And we're hoping tonight that's what we focus the bulk of our training on, is what are those proper procedures that'll help you get past any challenge. Because courts do not want to be the local government. They don't want to disturb a decision. But they will if you didn't follow proper procedures. So we're going to look at a few aspects of procedural due process. And I want you to become comfortable with that term, procedural due process. And if you find yourself in a meeting where you think, maybe we're wavering here, maybe we're not getting information correctly, maybe we shouldn't have 3 or 4 people talking at the same time, maybe notice wasn't properly given, that you can interrupt the proceeding and say, I'm concerned about our process here. Are we following the right process so that the outcome of this meeting can be upheld, legally defensible? So here we go. Time for some participation, true or false, Constitution. Every citizen of the USA has a fundamental right to life, liberty, and the pursuit of happiness. Who believes that's true? Yeah. Yeah. I heard somebody mumble, is it in the Constitution? It's not in the Constitution. And yet we hear this mouthed a lot. It's a Declaration of Independence. It's a 1776 document. The Constitution came many years later in 1789. But yet I still hear this at hearings, and you probably will too. What about my fundamental right to life, liberty, and pursuit of happiness? You're damaging my happiness if you try to regulate my property, and various forms of that. So it's just something to keep in mind that, you know, we're not all as well informed as we sometimes think we are. The Constitution is very specific. How about this one? Every citizen is entitled to compensation if his or her property is overly regulated. How many agree with that? Oh, wow. You can tell these are government people that sit on boards and commissions. That's why you're there, because you want to help shape what the public interest is and have that be considered in property. And this is right from the Constitution, the 5th and the 14th Amendments. I had occasion several years ago to travel to a country in South America. We scoff at it as Americans. It's Venezuela. Venezuela had passed a new constitution. And one thing I was impressed by is that it was on the back of cereal boxes. It was published in little pamphlets that people were reading on the bus. You'd go to a meeting, maybe it was a school board meeting, and citizens were talking about their constitution before the meeting. It was a really operating and dynamic document. You know, most of us, it'd be hard to find. I guess we can go on the internet and find it, but we don't think about our Constitution. As board members and commission members, think about the Constitution. I think you'll find it really instructive. You know, the Fifth Amendment, no person may be deprived of property without due process of law. Okay, so if I follow due process, see, there's a negative corollary there that does support regulation. Private property may not be taken for public use without compensation. We're pretty familiar with that. You may take my land and make it into a park, you've got to compensate me. But Fifth Amendment hints at allowing regulation, and this is what the courts get involved in. We're going to look at some U.S. Supreme Court decision, because recently they've construed the Fifth Amendment. That's what they dig into. Guys like Scalia and Kennedy and the rest, they're reading this and trying to figure it out. Now the 14th Amendment, that's how this applies to every state. And that came much later, 1868. It came after the Bill of Rights. No state shall deprive any person of life, liberty, or property without due process of law. Again, the emphasis is on due process. Your property may be deprived, maybe compensation's warranted, maybe not, but the focus is on due process. So that's our constitutional background. Be aware of the 5th and the 14th Amendments, that there is constitutional support for regulation of land. There is constitutional support for compensation if regulation goes too far. Well, how did we bring that into our state? Here's some words here. Uncoordinated and unplanned growth, together with the lack of common goals expressing the public's interest, poses a threat to the health, safety, and quality of life and joy of our residents of this state. Do we all agree with that? Yeah, you know, kind of, maybe, I'm not sure. Well, this is right out of the Growth Management Act. And that's why we're all in this room tonight, because the Growth Management Act required cities and counties, cities like Issaquah, counties like King, to adopt a growth management plan and to, under that plan, implement it with development regulations. Such a major change when this was enacted, because what it said was, we're no longer going to have a comprehensive plan that just sits on the shelf. We had decisions in this state, Shelton v. Bellevue was the key one, that said the comprehensive plan, even though everybody put a lot of time and effort into it, it's just a blueprint, kind of a guideline. We don't really care if development is consistent with that comprehensive plan. And that's what happened in the state. Unlike Oregon, that you had to pay attention to the comp plan, in Washington, it didn't really matter. And if it said that you can only do single-family residential, like it did in Bellevue, and someone comes in and buys the 100 acres and says, I want to put a shopping complex on there, that's okay. It was just a thought that it might be nice someday to have single-family residential. And the court upheld that. That's why the Growth Management Act passed. It was an initiative. People of the state were getting a little tired of putting all that time into planning like you all do, sitting on your boards and commissions, and then have somebody just say, that doesn't matter to me, I have a different idea. And that was a struggle for our state court, They couldn't find a way to say, no, you got to do what all these good people that spend time in evenings going to government sessions and planning, you got to pay attention to that. Of course, it didn't matter. So the people spoke up. You know, what a great system, democracy. And this was passed as an alternative to the initiative by the legislature, that all of this stuff that's on the screen and basically says you need to balance the public interest with private rights. Private rights do not dominate in this state. There is a public interest in regulating the development of land. Well, now here's one that, you know, I don't know if I agree with this. Each person has a fundamental and inalienable right to a healthful environment. It's pretty strong language. Who agrees? Any environmentalists in the room? You agree, but it's not happening? You are right on top of the law. I mean, isn't that amazing? That's a Court of Appeals decision that just came out. You know, that's what the judge wrote. I agree with this, but it's not happening. And it's from the State Environmental Policy Act. This was 1972?
71.
71. Each person has a fundamental right to a healthful environment. Each person has a responsibility to contribute. And this recent decision that came out of Court of Appeals, Division 2, by a newly elected judge said, you know, we've been ignoring this for too long. It's been in place for a lot of years. It's time to breathe life back into the State Environmental Policy Act. And the planners will recognize that, the planners in the room, that this is something that's been kind of with us the last probably 10 years of a certain segment of the land use community saying, let's just get rid of that Environmental Policy Act. We don't need it anymore. Yes, sir.
How many RCWs refer to a person's responsibility to do anything? That seems kind of...
It's pretty rare.
How many statutes, Revised Code of Washington, refer to a responsibility to do something? This may be the only one. Yeah, I mean, it's rare. You know, it's rare to see this. I should say this is in the findings. It's what the legislature found to be true. And early on, the court said, I think like you're suggesting, we're not sure we're going to require this of anybody, but we recognize it as an aspirational goal. The recent decision that came out of the Court of Appeals looked at a case in Spokane where the Parks Commission of the state didn't want to do another environmental disclosure. They said, we did one 20 years ago. That's good enough. And the court said, that's not good enough. This statute, the State Environmental Policy Act, still has meaning. And if those of you that think it's gone away, that we don't need it anymore, I have a different story to tell. We're going to breathe life back into it and require that environmental values be considered in decision making. And we mentioned this to you tonight because in your work as board members, commission members, if there's something in front of you that went through environmental review, not everything does, but every major action that could affect the environment, it has an environmental checklist that discloses what those impacts might be. It's supposed to look at mitigation of those impacts. And it's an environmental document that must accompany each decision that you make. So you want those in front of you. Early on here, some of you that have been around for a while would come in front of me, and sometimes, you know, maybe we didn't have every environmental document. And it's because they get misplaced. That checklist was done months ago. But we learned that we had to have it in front of us and reference it, and now everybody does in the hearings because it discloses information that we might want to pay attention to when we look at how we condition a land use application. So this is something you want to have in your mind when you come into that hearing room, that we need to be aware of environmental impacts of the decision. You know, the UVDC, especially looking at plats, and there's normally some environmental review. I think there's some exemptions now. What is the threshold for exemption? One of your planners know here in Issaquah? A certain number of lots, 4 or less lots. So everything more than that undergoes environmental review, and you should have, as part of your review process at that hearing, a copy of the environmental documentation. The threshold or the decision that says there is no environmental impact if you comply with these conditions, and the checklist that discloses what the impacts are. Now we're going to segue into another area. Did you want to read this one?
Sure. So our next true-false question, it's okay and even a good idea sometimes to hold more than one hearing on an application so that everyone gets a chance to speak.
That sounds fair, don't you think? Anybody disagree with that? Oh, Jason, huh?
I cheated.
You cheated.
Yeah, where we had this discussion a few weeks ago.
Well, then you should know the answer. And the answer is, yeah, yeah. And what's being alluded to here is the Regulatory Reform Act, 3670P. I think that should be 36. I don't know. I wrote it down. It's at the time of Growth Management Act, then there was a Regulatory Reform Act and the Land Use Petition Act. They kind of all came in together. Major changes in the middle to late 90s that turned the world on its head in land use planning. And this you can see by 1996, each local government shall provide for, and there's a whole bunch of things. Timelines is one. Talking with Christopher Wright just before this began, you know, your city's looking at reducing its review time from about 180 days now, cutting it in half. And that's regulatory reform. We had applications in the system, particularly Boeing applications in the city of Everett or Mukilteo, that were months under review. And if Boeing isn't getting what it wants, it goes down to the legislature. And we've got to change that law. We're going to force these local governments to make decisions in 120 days or less. And that's what happened. And along with that, there were so many appeals. You could tie up. You know, any one of us could tie up. And attorneys were doing this. They would appeal the environmental documentation as a separate appeal. No land use decision was made. The appeal was, this EIS is not adequate, and you can't move forward until it's adequate. And you could hold up a project, if you went through the court system, easily 4, 5, 6 years. And that's what was happening. And then it might be remanded. The court might decide, you're right, it's not adequate. We remand it to do further environmental review. Now another couple years go by. Then you challenge that. And that's what happened. And each one of these would come up at a hearing. And you didn't even have the hearing yet on the permit application. That's a whole separate process. So things are going on and on and on. And now it's very clear. And this is another little hint or a little elbow in the side to the Issaquah planners. One hearing on an application. One hearing. Now, there are laws in place that maybe are inconsistent with statutes, local ordinances. I see them in other towns and cities. And it's kind of okay if nobody challenges it. You know, it's not like there's a big penalty attached to it. But you want to be aware of where you might be vulnerable, and you want to be careful that if you're holding more than one hearing, that it may run afoul of our state statute guidance. So just be careful on that. Again, it's one of those things when you walk into your Board of Commission room, you're just thinking, I know there's something about only one hearing, so I want to be careful.
Can you clarify, Ted, the difference between a hearing and a meeting?
Well, yeah, that's a really good question. Because most of you are doing public meetings. You may call it a public hearing, but you're really bringing people together to meet and discuss a policy, in the case of the Policy Commission, or rivers or streams. But I believe the UVDC is actually looking at applications. And do you call that a hearing? I think you do.
Well, another question is, can hearings be extended to another date? Can it be a two-part public hearing?
Can you extend a hearing to another date? If you do that extension carefully, we are going to continue this hearing and reopen the hearing at a later date. You can't re-advertise. You can't call it something different. And we're going to get into that a little bit on notice when we talk about notice. But yes, you can continue to another date. That's the same hearing, but on 2 evenings. But what Andrew asked is key, a meeting and a hearing. And a hearing has the attributes of a court review. It's what I do. We ask people to testify under oath. And we'll get into that a little bit when we look at procedure due process. It has the trappings of a court proceeding. A public meeting is less formal. People can sign up to speak. They're not testifying. You're gathering information. But think about this as we go into procedure due process. How you use that information is really important when you make a decision.
And one final thought there, on the hearing versus the meeting, to go back to the beginning, Open Public Meetings Act does not apply to hearings. That's so one way to think about it is if it seems like you're deciding an issue for a specific applicant, that's going to be a hearing. Whereas if it's more of a general proposition, bigger picture, that's going to be a meeting.
So let's stop here for a minute because we covered Open Public Meetings Act. That's all we're going to do on that. You're aware of it now. You know you're under that unless you're doing a quasi-judicial hearing, which is what I do. We've covered the background of the constitutional and statutory framework. Okay? So we might pause for a minute and see if there are questions in those areas.
On Open Meetings Act, maybe you can point out a few of the things that could get boards and commission members in trouble because it creates an open public meeting, but unintentionally, like use of email or conference call.
Okay. The question deals with Open Public Meetings Act. When you're using emails or conversations that aren't in a specific hearing room, when might you run afoul of that, or to be aware of that, you need to bring that into your thinking?
I can field this one?
Yeah, you
So,
bet. You're the expert.
Actually, Washington appellate courts have actually said it's possible to have a meeting via email. Nobody is quite sure how to deal with that decision, but part of the only way you can really be in trouble for an Open Public Meeting Act violation is if you know that you're committing a violation. So if you're just, casually sort of conversing, and then you happen to get into something that you're ultimately going to be deciding, just remember, oh, maybe this is something we should wait till our next meeting to talk about. And the other thing is, even if you were to say decide something, as long as you later make the decision at an open public meeting, that subsequent decision is not going to be null and void. But as a general rule, if you're thinking to yourself, is this something we should probably be doing, out in the open, that you probably should be doing it out in the open. So if you're actually just sort of deciding issues rather than just sort of, briefly thinking things through.
Let's take a couple more questions here in the front and then in the back.
Clarify something you said. You said that open public hearings do not, Open Public Meetings Act does not recognize hearings. That's how you said it, but there cannot be a violation that the Open Public Meetings
Right.
Act hearing.
That's right. The Open Public Meetings Act is created by statute, and the statute, RCW, has an exclusion if it's a quasi-judicial hearing. And quasi-judicial, quasimodo, it's kind of an odd term, but it refers to you're not an elected judge, but you're sitting on a board or you're a hearing examiner, and you're looking at a specific application or an appeal that affects individual rights. So that becomes like a trial court. That's judicial. If you're not a trial judge, quasi-judicial. That's exempt from the Public Meetings Act. So does that help?
Thank you.
In the back?
Just real quick, do email could transfer back and forth between members on the board or planners? Is that covered properly?
Emails that go back and forth between a board member and a planner, is that subject to the Public Records Act? Would be a way to look at it.
Can be.
Is it open?
Information Act, is that part of all that?
Most definitely. That's the type of thing that someone would request. And there are some redactions, personal information or personal discussions, but anything related to business before the board or commission that you're on, yes, that can be disclosed.
Whereas if it's a hearing and you're deciding something as a group, that is not subject to the Public Records Act. So
Right.
if you're acting as a judge, the public doesn't get to know why a group of, say, 5 people decided to go with, a certain way on a decision. So when you're acting like courts, the public doesn't get to know your deliberative process.
Thank goodness, because I'm doing a lot of doodling and some sketches on the side and little notes, and yeah, that's not disclosable. So, okay, anything else on open public meetings or the statutory background? We looked at the Constitution, 5th and 14th Amendments. We looked at Growth Management Act, State Environmental Policy Act. Seeing none, we're going to launch into takings, because this is something you're all dealing with. We deal with this in our personal lives, perhaps, in discussions. Since you're all interested in how the city is evolving and developing, this type of thing will come up. It comes up in elections all the time. and hides under various guises. I believe in personal property rights. Yeah, what about regulation? What can we do? So we want to look at basically three areas. Condemnation we put on there is one way that results in taking of the property. But when regulation goes too far, what is a physical intrusion that results in need for compensation, and when does it take all reasonable use of property away? So we're going to touch on these cases. These are ones that you kind of want to be familiar with. It may impress somebody at a party, but besides that, doubtful. But you kind of want to have in the back of your mind as you go into your board and commission meeting that this is how it's evolved. So starting 1922 was kind of the first takings case. Grand Central Station in New York. How many have been through Grand Central Station? Yeah, most have. And you go back in the 1920s, and the railroads were going full steam. Things were going pretty well. And Penn Central wanted to expand Grand Central Station. They wanted to put another layer on top and kind of build another building. You've heard this story before. Okay. Yeah. And it's interesting because the city of New York said, well, no, we're not going to allow that. We think it has kind of a landmark status. It looks really cool how it is. We don't want you to disrupt it. And Penn Central went to court and saying, if you don't allow us to do this, expand our building, we're going to go out of business. We don't care. We think it's that important. And they went all the way to the U.S. Supreme Court and argued that the regulation went too far and it was a taking, and they wanted compensation or else invalidation of the New York ordinance that prohibited them from expanding the building. Well, the U.S. Supreme Court said, we kind of agree with the city, because when we look at the economics of it, it looks like you can still operate profitably without expanding the building. And there's a public interest in the architecture and the way this building looks. Well, that was kind of a blow. And in fact, the outcome was Penn Central did go bankrupt, and they did not expand the building. And the Metropolitan Transit Authority of New York purchased it, and it is what it is now, supported in part by tax money to continue to operate. So this is the only guidance, though, we got from the court is the court said at some point regulation may go too far, and we would agree with you, Penn Central, that it's gone too far, but not in this case. And it didn't offer much guidance at all. But we knew for the first time that the court was, through the 14th Amendment, applying takings to actions of the state, which includes local government. Then along came Euclid. Most of you heard of Euclid versus Amblin Realty. Yeah. Classic case, zoning, and the lawsuit was you can't do zoning that regulates property. And the court said, no, we uphold zoning. Because if we gave compensation for every action of government that may reduce the market value of land, government would cease to function. Because most of what government do is going to have an impact on the marketability of land. Sometimes up, sometimes down. And the court did not want to get involved in scrutinizing whether any action, including in this case zoning, would benefit a property owner or harm a property owner. So they allowed for zoning. It was the type of action that is intended to protect the public health and safety. Am I doing Laredo too?
Sure.
You're coming up though, right?
Yeah.
Okay. And the next case, Laredo. So between 1926 and 1982, all we had for guidance was it goes too far. And that's why it became such a strain. And that's about, in the early 80s, mid-80s, I started doing hearings. And it was a real struggle because people would vigorously argue, this goes too far. You can't regulate me this way. And others would say, no, we need to do it to protect the public health or safety or welfare. So along comes 1982 in the Laredo case. We begin to get more guidance from the court. And here the court said it was a case in New York City again, putting kind of telephone boxes on apartments so that they could have this telephone network. And the court said that goes too far. And in fact, any physical invasion of property. And it's happening right now in Seattle. The city of Seattle is looking at putting boxes in the front of your house, what's called the parking strip. And most of us think, that's my parking strip. I put a little garden in there. I planted some trees. David, I think you have some real nice stuff in your parking strip. Yeah. But the city says, we're going to put communication boxes there. And people are outraged. How can you do that? Well, it's not your property, number one. If it was your property, it's in the right of way, but if it was your property, Laredo would apply. And the government can't just put something on your property without compensation. So that gave us some guidance, but we still don't know about regulation. We know you can't take it. We know you can't put stuff on my property. How can you regulate? And this is a string of cases Andrew's going to touch on that changed the world when it came to crafting conditions on land use approvals.
So the first of these was in California. It was Nolan versus the California Coastal Commission, and Nolan had a nice beachfront property, but kind of an old bungalow, and he wanted to build a nice new house, much bigger. And the California Coastal Commission said, yeah, that's great. We're going to let you build your nice new house, but only if you provide access to the beach. So you need to have a right of way so that the public can go over your land and access the beach. And Nolan said, no, I don't think you can condition it that way. I don't think that I need to, let the public walk over my land to get to the beach. And ultimately, the Supreme Court said, yeah, we agree with the property owner. And the problem was that he was seeking a permit to build a bigger house, and the condition had to do with beachfront access. So what the Supreme Court sort of said was that you need to have a substantial nexus between the condition and what the party is actually trying to do. So in this case, they said, the beachfront access really has nothing to do with the size of your house. You're dealing with apples and oranges. You can't make a condition like that. So that was the
and
first.
Planners recognized this. It became part of their lexicon, became part of the vocabulary. There must be a substantial nexus and rough proportionality between the impact of the proposed use and the mitigation of that impact. And in nearly every hearing, and I think UVDC hearings, that probably has become or should become part of your dialogue. What is the nexus? Is it proportional? Does it mitigate the impact? And are you going to touch on Dolan? Because I love Dolan.
No, go ahead.
Dolan's from Oregon,
Yeah.
where I grew up. And so I visited this hardware store. And the city of Tigard, most of you have been through the city of Tigard. Next time you go through, you want to look at this H&H Hardware. I think it's called H&H Hardware. Mm-hmm. It's a hardware store where the city said, you can build your hardware store, but you have to also construct this portion of a bicycle trail that's going to come in front of your hardware store. And the Supreme Court dialogue is fascinating because U.S. Supreme Court justices, when it finally got there, they're asking questions of the attorney for the city. How many times have you seen someone on a bicycle carrying a 2x4? And the guy kind of said, well, I think it's possible. And the judge says, is possibility enough to result in contribution to build a bicycle way? And clearly they were signaling they didn't see the nexus, like Andrew just touched on. What's the relationship? If you carried hardware items on a bicycle, I think the U.S. Supreme Court would have upheld that condition. But as a matter of fact, they struck it down and said, no, you cannot. There's not a substantial nexus. The impact of traffic, additional traffic going to the hardware store, is not mitigated by allowing bicycles to go to the hardware store, because nobody's going to carry hardware items on their bicycle.
And then the last case I want to touch on is from 1992. So remember, we started in 1922 with Penn Central, and we know that it's possible to regulate too much, but this isn't that case. And finally, in 1992, the Supreme Court finally said that's too much. So in Lucas v. South Carolina Coastal Council, a gentleman had a real nice beachfront property again. Might have been an island, actually. Yeah. And they passed some new regulations that ultimately meant he wasn't going to be able to build his dream mansion on his private island because it was going to be against the regulations. And he said, hey, you've essentially eliminated all economic value of my property. I had this plan for this house. There's not much I can do with this property. Otherwise, you should pay me for it. And in a very split very impassioned 5-4 decision, the Supreme Court ultimately said, yeah, you did go too far this time. This is how we know you went too far. And if you have eliminated all economic value, you've gone too far. So that's sort of the line that has been drawn. So there's really only two ways that you have what we call a total taking of property. One is the situation in Loretto, where you physically, the city wants to put something on your yard. They have to pay you for that. And then the other is if you have a total taking because now there's no economic value to the property. And actually in the dissent in that case, I think it was Justice Breyer, I think, but essentially said, well, this doesn't make a lot of sense because if he could still have 5% economic value, we wouldn't owe him anything, but if it's 0% economic value, we have to pay 100%. And the majority said, yeah, well, that's where we're going to draw the line. So now we kind of know where the line is drawn. So as long as, you don't leave it totally economically useless, it's not going to be a complete taking.
Yeah, and our state was way ahead. We had a decision in 1980s, early 80s, I think, Kreidler versus Ecology, and it was in Mason County on Hood Canal. And we're all familiar with Hood Canal, and this is a Shoreline Management Act decision. Mason County, believe it or not, had a section of the Shoreline Master Program that said certain properties along Hood Canal cannot be developed with a single-family residence. In part, it was steep land. In part, they didn't want obstructing views driving along Hood Canal. And Kreidler challenged it and said, that's not right. You're taking my property. That's why I bought it. I mean, we've all heard this. I bought it because I want to build a home on it. You can't take it. You got to pay me for it. And our state Supreme Court said, no, you can still make use of that property. You can sit on it. You can observe sunsets. You can go down to the beach through that property. It still has value. Now, our state really goes in two directions. Andrew mentioned reasonable economic value, reasonable economic use. Some ordinances just say reasonable use. Can you make a reasonable use of the property? In Mason County, they said you can still make a reasonable use. They didn't get into economic value. And this is still a struggle in takings. So on your boards and commissions, when you're dealing and interacting with your city council, you're kind of asking these questions. How much economic use can be made? How much use can be made of the property? And you can distinguish between those two. And then if you get into a dialogue about whether you've gone too far, you've taken my property, in this city and most others, there is a way out. There's what's called the reasonable use variance. And we've had a fair number of hearings in this room on reasonable use variance, where the starting point is, yes, you set a 300-foot setback from the stream, you took the entire property, you say they can't do anything on it, but we'll give a little variance for that so that you're not having to compensate to take the property. So you get in a sense how takings works. We wanted to leave you with on takings is just, it's an evolving area. There is more guidance today than there ever was before. Your staff is well informed on takings and rough proportionality and substantial nexus. And those are the types of dialogues you should get into. And you may not even use those words, but you can ask the staff, you're recommending a condition, what impact does this address? How is it related? You're telling me that on this plat that if they set aside this open space, it's going to somehow benefit children that are in the plat. But what's a tot lot? Does anybody use a tot lot? You can ask your staff questions like that, and they should be well versed enough to say, we're familiar enough with tot lots in this area that we believe the children will use it. Whatever the nexus might be, but establish that in your hearing. So that's takings. We'll pause here for a minute. Any questions about takings? You feeling overwhelmed, like that's too much information, or is it too simple? You get it. Okay, I'm getting nods. That sounds fine. Yes, Lucy.
So, for staff today, could you speak a little bit to if conditions are directly related to existing city standards as opposed to conditions that are maybe more interpretive of, say, guidelines or other, and how that relates to nexus and
Yeah, what Lucy's asking about is the types of conditions, and this is some progress we've made in this city and others. You have, when you look at conditions on an application that allow you to recommend approval, some of those are required by your ordinances. And those are kind of what I call courtesy conditions. They have to comply with those anyway. By listing them, you're giving them a heads up. Make sure you know that you've got a setback of 20 feet in this area. Make sure you know that you have to plant trees if you cut trees down. Already required in the ordinance. And those, someone may challenge, but not in our hearing rooms, because I'm sworn to uphold the laws of the city. I'm not someone that's going to override the laws of the city. That's for a judge to do. So there may be a developer that challenges one of those conditions, but they are automatically applied. The other ones more intriguing are ones that I think we're beginning to call conditions unique to this application, and even under a separate heading. And that's where all this taking stuff comes into play. Now, planners won't often venture into that world because it's tricky to make that balance. But they may ask you to give us your thinking on the board, give us your thinking on the commission of whether or not we should adopt this as an ordinance, whether or not this condition should be applied to applications. And that's where you get into the balance and the challenge of, does it go too far? Is there a substantial nexus? Does that help? Okay. All right, we better look at procedural due process, because this affects everyone in this room that's on a board or commission. You're opening up either the meeting or the hearing, and we don't care now. We don't care whether it's a meeting or a hearing, because these steps, these 4 considerations, apply to what you do, and we believe if you adhere to the guidance offered here in this next 10 minutes, that you'll have a better meeting, a better hearing, and your outcome of that will be less likely to be attacked. Because these things we're going to talk about are designed to have everyone participating in that hearing, the people that come, feel like and are in fact treated fairly. The best outcome you can hope for if you're running a hearing, how many preside at the hearing or the meeting? We've got a few presiders in the room. And you know the challenge, and I'm in that position too, of, I don't want to look like I'm biased one way or the other, and I want to treat everybody with fairness and respect. And what you're hoping for, what the best accolade that you can get is when someone says, I don't know how you're going to decide this eventually, but thank you for listening. I'm glad you listened to me. I felt I was treated fairly and with respect. And every time you do that, you're building a little bit more credibility into local government, into government generally. And those individuals treated fairly and with respect will be less likely to complain about government generally. And they'll see, maybe I can influence in a positive way. So this is, I think, really important stuff. So here's Andrew. You can give this first test question.
All right. It's okay for me to sit on a board where I hear about land development proposals, even though my bank funds many of them.
It's okay. Anybody agree with that?
Talking about Bank of America?
Yeah, let's talk about Bank of America. Yeah.
Well, can I clarify the question too? Is this to sit on a board where I hear about land development, or is this staff and decision-making process?
Excellent. So here we have a distinction between the quasi-judicial and the board or commission that's just looking at policies, for example. And it's the difference between hosting or having a public meeting and one where you have an open record hearing. So here we're going to talk about, this is an open record hearing. In the meeting, no problem. You want people from all different backgrounds, and hopefully others know who they are. You're not hiding anything. But now you're going to make a decision. What do you think? Does that make a difference? Yeah?
I don't know. I mean, I bank with U.S. Bank and Wells Fargo and Bank of America. I have no idea what they're funding, what they're not funding. My bank might be where I bank, or it's my bank I work there, it's my bank I own, and I'm on the board. So I think it really depends on what your relationship is.
Excellent. Excellent. Yes.
Isn't it a matter of disclosing it in public? I mean, it says sit on a board, so you don't know what's going to come up next year.
Right.
But when something does come up, you can either recuse yourself, or you can make certain that everyone there and on the public record knows of your potential or apparent conflict of interest.
Yeah. And for the record here, and up in the room they're recording this, yes, the comment is, from here, yes, it really depends on your relationship with that bank. It depends on how directly the connection might be. And here the comment was, well, if you disclose a possible conflict, doesn't that cure it? And you're both in the right area. You're both saying the right things because, yeah, that's what you need to think about. How closely am I aligned? And if you think you go over a line where it might appear, not actually influence you, but it might appear. I bank with United Bank, and I think they said something about funding that plat. Last time I was talking to my loan officer. I better disclose it. That's what you're talking about. If you disclose, I have a bank account at United Bank, they may be involved in this project. Does anybody object to me making this decision? That cures any defect, that it cures, that develops the appearance of fairness that the court was looking for. It was originally a judicial doctrine, and now it's captured in state statute, in the RCWs. Do you have a thought on that as well?
Yeah, what we say is that, it's not just that a decision is fairly made, it also has to appear to be fair to all outside observers. So in the judicial world, the idea being if a judge knows someone, even if they think, I wouldn't have any problem deciding this matter, the outside world might question it, and so judges might recuse themselves in those circumstances.
Well, can I seek clarification on the issue of recusing?
Uh-huh.
What is the dividing line between making a connection or a possible conflict of interest known and saying on the record and saying I cannot participate in this particular application process because whatever?
That's a good point. The question is, when do I recuse myself or take myself out of the situation? And that's really up to you. If you disclose, it's followed by, even though I have this connection, I believe I can hear it fairly. Does anybody object? If nobody objects, you're fine. The different situation is, I'm so closely connected. I mean, after all, this is my son that's proposing this. I don't think I should participate. You remove yourself. So that's the way that works. And remember, this isn't just for, as was pointed out here, is this only quasi-judicial. I think in any situation, if you're on a parks board and that park is right in your neighborhood that you're thinking about spending a lot of money improving, bring it out. This happens to be one where I'm really interested in. I still want to be participating in the discussion, but I think people should know I'm really interested. That helps. It helps make it more fair. That's exactly what we want to leave you with. Following this guidance that comes out of the courts where there was liability attached is also helpful when you're on a policy commission where there's not going to be any liability, but it's just good general practice. And here's part of what due process. So due process is I must be fair when I'm on a board or a decision-making body. Also, there must be proper notice. What do you think?
Yes.
Is it okay to hold a hearing even if someone at the hearing claims they did not get proper notice? I see a lot of heads going, yeah, that's okay. Well, it's kind of easy in a way because they're at the hearing, It's like, how did you get here? Divine intervention? What happened? You're here. How can you complain about it? But these cases do come up, and they do go through the court system. And I'll give you a little just insight into how they emerge. In fact, we have one in my office right now from another jurisdiction, now never involving Issaquah. But we have all sorts of affidavits from people that should have received mailed notice. It's a big development next to their condominium. It involves 32 or more, 44 residences would be constructed. And it's happening. They made the decision, and these people are trying to appeal, and they claim, no, you never responded. You're not a party of record. Well, we never got notice. Stack of affidavits. None of it. City says, well, we gave you notice. Now, I'm going to hold a hearing on that question. It's a factual question. In this city, you do it really well. You've got a nice affidavit of notice. You attach, these are the address it was mailed to. I don't have that evidence yet, so we have to go to hearing on notice. So it does happen, and it's really an important part of due process. And another situation out of Spokane County is where the posting, and you do a posting and you do mailing, you do publication. Nobody reads publications. I mean, let's face it, it's in the newspaper, but I don't think many people see that. They will look at a letter if it doesn't look like junk mail. But a lot of people will see that posting. Do you do the 4x8 board? A lot of cities still do the 8.5 by 11 on the telephone pole, and that's pretty challenging. But your 4x8 board, people are going to see that if in the proper place. And this is something you might want to think about as planners. In Spokane, it was a subdivision of land. There was kind of a major road that went on, let's say, the south side. And then there was a minor road that went up to the north off of that road. And maybe there are 2 or 3 residences up there. Well, the developer said, yeah, I posted the property just like you told me to. Well, he put it on basically a driveway. And people were outraged when this was approved, and they felt like they didn't get proper notice. So the court said, you're right. Notice has to be reasonably calculated to give actual notice. So in that case, they invalidated the hearing that approved the subdivision and said you need to go back and do notice correctly, which is posting the property where people will be more likely to see that there's a hearing coming up. Yes. 300-foot buffer for notification, mailing to 300-foot circle. How did the city of Issaquah decide that? It's kind of arbitrary. Most cities have 200 or 300 feet. Were you around when they did 300 feet?
I did, and I just remember polling other cities, and that was a typical distance.
Yeah.
GIS analysis that creates a buffer of all the properties outside of 300 feet of the subject property.
GIS analysis shows that the 300 feet is kind of the buffer that within that 300 feet you might be impacted, but beyond that you're less likely to be impacted?
Well, our ordinance states that those Issaquah property owners within 300 feet, we identify that property and then buffer it via GIS to capture all the property within that.
Oh, I see. Okay. Buffering of the properties, all right. Do you have a comment on this one?
Yeah, just along those lines, by ordinance in Issaquah, and a lot of cities do have this, where you do need to notify adjacent property owners or within 300 feet, sometimes both. But under the Growth Management Act itself, individualized notice isn't required, isn't necessarily required. But here in Issaquah, that's a non-issue because you are going to, by your own code, you've sort of gone further than was required by law at the state level and said, we're going to make sure that we get individual notice to people in this, in this particular area.
And this is a practical thing. If you're on that board and commission and someone shows up and says, I didn't get notice, I mean, you can look at them and say, you don't need to get notice. But it's unlikely you'll do that. So it's not a smart thing to do. So, welcome to this proceeding. We do want to hear from you. We'll make sure you get notice in the future, that kind of thing. If you hear it a lot, you might start looking at how you're giving notice, because it has to be reasonably calculated to give notice. Let's look at another one. If I'm on a board that makes decisions, can I recite to my own knowledge of a proposal and of land that is proposed for it before I make a decision? After all, I know more about the property than staff or the applicant. What do you think? You're sitting on these boards and commissions, and if you're going to make a decision, shouldn't you bring your personal knowledge into it? Doesn't that make sense? No, I see most people, no, you really shouldn't do that. No, you really shouldn't do it. I cannot do that at all. One reason you have a hearing examiner that doesn't live in the city is because, I don't know, you have to tell me what I need to know. And I'm going to listen to staff and the public and the applicant, and I'm going to make the decision only on the record. And that's the key thing. And again, I think it affects all boards and commissions. If you host a public meeting, it's not a hearing, it's just a meeting, and people start telling you stuff and you're listening to them, but then you sit up there and you go, well, nobody talked about the wetland that's in the northwest corner of this property, and I know it's there because I walked the property, and I think we have to pay attention to that. You're beginning to wander outside of why you're even holding a public meeting. Let somebody, you might ask the question, how familiar are you with the property? Do you see that there's a wetland area up there? Has that ever been something you've thought about? Now you're putting it on the record, getting somebody else to testify or speak to it, but you're not using your personal knowledge to influence the outcome. And that goes to fairness, and it goes to how I feel it's fair, because I don't want to spend time going to a meeting and then have the board members disregard my testimony and rely on their personal knowledge.
Before we move on,
Yes.
So most of our agendas typically will have public comment or discussion, and then we'll have commissioner discussion. And then I think that's what it's called in meetings typically. And often that's going to be, I live in Issaquah Highland when I've seen this. I live in Dallas and I've seen this. How was the depth?
Yeah, I think that's dangerous. I mean, thank you for giving me some insight in how you do it, and it becomes customary over time. We've heard the public speak. Now let's have the commissioners discuss it. And I think what you're sharing with, that often becomes what the commissioners know. And it becomes kind of your chance to testify. And I think that's a little dangerous in that you may be very well informed, but again, there's other ways to get that information that the courts will look at. Are you basing it on your personal knowledge or on the record? And what you want to be thinking about is, how do I get this on the record? So it's very fair. You see some plats that come in front of you. Is that right? You ask the applicant, in Issaquah Highlands, is it true that there has been some commercial development recently? Has that changed? And maybe they know about that. You know they know about it. And I often tell the planners this, please don't be offended when I ask you a question that you're thinking, how dumb are you? You should know the answer. I do know the answer, but I want to get it on the record so I can reference the record. It just elevates you if it is challenged in a court or you're doing a recommendation. Somebody may want to challenge that recommendation in front of the council. And if it's based on the record, the courts will say, that's what you need to do. You can't bring your personal information in. Now, it's tricky, but you're the chair.
Yeah, if I could expand just a little further, what if it's based on information we had from a previous application that was similar or that we heard 3 years ago or something, which is on a record, not necessarily the record, that particular thing. But we oftentimes revert back or harken back to some of those conversations.
Yeah, how do you refer to past decisions that are relevant to the one you have in front of you? And again, you might think about how you ask that question. You've got staff in the room, and you can even do this before the meeting. Hey, I'm going to ask you about that one we heard a few years ago. Can you bring that into the room? And they might even have the file there. And asking staff to speak to it, you're really giving a lot more support for your outcome. Because if someone challenges your recommendation, one challenge can be, it's not based on the record. It was based on personal knowledge or your recollection of what happened. And you can rely a lot, I know I do, and rely on your staff. I mean, just pester them with questions. Just see if you can trip them up. But that's why they're there. And use them that way, because your thinking on this is, I need to get it in the record, and it would be best if somebody spoke to it.
I know, sorry, can I get one point? Isn't if we say it in our discussion and the record being taken of that discussion, isn't that part of the public record then?
If a commission member is talking about it, isn't that part of the record?
If the person is taking notes on record and that's part of the minutes?
It is recorded as part of the record. Now, in my situation, I'm getting testimony under oath. I'm not sure if you are or not. You're not. So, there's a difference between testimony under oath and just somebody speaking. But you're on the same level as everyone else that's commented. It is part of the record. The point I'm trying to make is people will have more confidence if it comes out from an applicant or a participant in the hearing, because the thought is these commission members are listening to what's being disclosed to them and then making a decision based on what's disclosed. And it just gets into dangerous territory if you are basically testifying and then, based on my own testimony, this is what I think should happen. It sort of looks like you're excluding. The public is now less important. You see, it's maybe a little gray area, but the courts have said, base it on why you invited them into the room. You wanted to hear from them. If you didn't need to hear from them, you could have just made the decision without them. And we know you need to hear from them.
Sometimes we don't even have the applicant.
Sometimes the applicant's not present. Rivers and Streams Board, and the applicant doesn't show up. Yeah, they should be there. I mean, I have canceled hearings. We've waited 15 minutes. The applicant has not appeared.
We're just sharing a project.
Oh, this is early on, looking at a project, and they want to get your input. Yeah. Well, you have some representation from the applicant. They've disclose something to you, an application, yeah, but they're not there to advocate. Yeah. Well, that can work. You're in a specialized position with rivers and streams, giving your input to what you think, but not deciding it.
Right.
Yeah, that's permissible. Keith, did you have a question?
I think the point is it's about sequencing, and it's about, as a commission member, you can say what you want. You know, if it's before the applicant makes their presentation and before the public gets to comment on it, it becomes sequentially in the right spot. If you say it afterwards, when the public doesn't get a chance to then address that issue, the applicant doesn't get a chance to address that issue, it becomes much more of a procedural, I think, bad spot for the commission.
Well, thank you, Keith. That's a really good point. He's talking about how the hearing or how the meeting is perceived to be fair. Everyone should get a chance to comment. And if the commission makes comments, the applicant doesn't get to respond or public doesn't get to respond, that's not fair. And that's the guidance. Every meeting, every hearing I do, I'm thinking about a key case, came through Division II, I believe, Weyerhaeuser versus Pierce County. And that decision, eventually by our state Supreme Court, gave very specific guidance along the lines Keith's talking about. If somebody makes a statement in a hearing, you need to allow the other parties an opportunity to respond. So, you know, in the situation you described, commission member, and, you know, I think this is a really good idea because I walked there yesterday and I can see that we really need to have double landscaping. There's a scenic protection or protection from obscure view, whatever. If they don't get to respond to that, that's unfair. And that's what Weyerhaeuser versus Pierce County was about throughout a decision. So very specific guidance on this that we're not going to get into tonight, but just want you to think about it. Are we being fair here? And finally, we're going to just touch on the decision. You know, should it be written like a good book? Well, I think mine usually are. People love reading them is what I hear. And here's the guidance we have. And you will follow this. And in my office, people do get like, do we have to keep writing with the same format? Can't we do just a narrative decision? And I'll tell you why not. And I practiced real law, did trial law for about 10 years, and go into federal court, and especially district court. And Andrew understands this because he's seen some of the appeals that come. And I'd have judges listen for a day and a half, and then they would write a one-line decision. We rule in favor of the defendant. What? What? Tell me why. What went wrong? And I'd be so frustrated. So when I came to do this kind of work, we built this structure. Each fact must be related to an exhibit or testimony. So you do findings of fact, and some of you see these, especially I think UVDC. Each conclusion must reference a fact and the criteria. The decision must follow from the facts and conclusions. And you can write real defensible decisions if you keep this mantra in mind. And I don't expect you to remember it, but I hope you think about when you come to that decision or recommendation or how you view what an applicant is proposing. Think about it as facts that are in the record, that how you conclude is based on those facts, and that the recommendation or decision flows from. So, I mean, that's kind of it. You know, some of what you need to know, go forth and make decisions and recommendations. And I thank you for your attention. I think we have time for a few questions. We'll take a question here. Anyone else? And here.
What personal liability do commissioners have?
What personal liability do commissioners have? It's a real active area of law. And what happened in this state in 1991, our state Supreme Court applied civil rights liability. Federal statutes adopted right after the Civil War, our state court said, it's called 42 U.S.C. 1983, that liability attaches to land use decisions that are made after failing to follow proper procedures. And I won't get into the details, but it is individual liability. That's why I'm doing what I'm doing. Right after that court decision, there was a footnote in that court decision. In fact, that's why you're here tonight. The failure to train on proper procedures, our state Supreme Court said, can in itself be a basis for liability. And it was wild. It just changed the world of land use. I went to the city insurance authority and I said, have you seen this? And they go, oh my gosh, what can we do? I said, well, we can go train people on how to do hearings properly. Great idea. So it changed my world, and that's why I'm a hearing examiner today. So that's a good question. Think about it. Be fair in your hearings. In here, and then one more here.
Is this material going to be available to all of us?
I can make it available. If you'd like to see it, I'll work with Kathy on that.
I'd like to see it. It's been filmed, so any commission member that's not a hard copy, hard copy.
Yeah, they don't want to see me again.
I think we have this hard copy.
Yeah, we can do that.
The second thing is, at what point, if meetings start getting out, it's just theoretical for the development, because I have experience here. If it gets out of hand, people get really boiled, what authority does a commission chair have to say either out or whatever?
You have a lot of authority. In fact, you have a responsibility. And there's a whole separate line of cases on that decisions or recommendations cannot be based on influence of a hearing, either boos or hisses. You've got to take control. And a simple technique, just a little hint on that, is come up with a set of rules. I'm chairing this meeting tonight, and I think it's appropriate that it's starting at 7. We need to be done at 10. No one wants to go past that. You all agree? Yes. Can you then agree to restrict your marks to 3 minutes because 10 people signed up or whatever? Yes, we all agree. And would you all agree no applause or no boos? Yes, we all agree. And then you can come back to that. Listen, we all agreed at the outset there'd be no boos or no applause. Please don't do that. And if that still doesn't work, I'm going to take a 5-minute recess, and when we come back, we need to be calm and under control or the hearing will not continue, and we'll have to reschedule to another date. And you can be confident about that. You will be supported by courts for sure. Okay. Hey, I think we ran out of time. I really appreciate your time and attention. We do need to turn, can we have everybody turn a chair?